All right, so we're almost done. So we're going down the rabbit hole. We want to indemnify the insured as quickly as possible for the best, highest indemnity possible without sacrificing any of their rights. And to do that, you have to follow the terms of the policy. And the most important part of the policy when assisting an insured with a claim is the duties after a loss. And the duties after a loss says you have to have a signed, sworn proof of loss. And you submitted this signed, sworn proof of loss in accordance to the policy and the statutes. So what is the insurance company's duty after you've done everything that you could for the insured, following those duties after a loss? Upon the insurers receiving a communication with respect to a claim, the insurer shall, within 7 calendar days, review and acknowledge receipt of such communication unless payment is made within that period of time, or unless the failure to acknowledge is caused by a factor beyond the control of the insured. There goes that factor beyond the control again. If the acknowledgement is not in writing, a notification indicating acknowledgement shall be made in the insurer's claim file and dated. A communication made to or by the representative of the insurer shall insure with respect to the claim shall constitute communication to or by the insurer. As used in this subsection, the term representative means any person to whom the insurer has granted authority or responsibility to receive or make such communications with respect to claims on behalf of the insurer. This subsection does not apply to claimants represented by counsel, right? So such acknowledgement must be responsive to the communication. So does that mean that they just say, hey, we received it? Or should it be responsive to what you actually sent? This is saying it should be responsive. If the communication constitutes notification of a claim, unless the acknowledgement reasonably advises the claimant that the claim appears to not be covered by the insurer, the acknowledgement must provide necessary claim forms and instructions, including appropriate telephone numbers. So what this is saying, I still say that in your notice to insurance company, you should always ask for all necessary claim forms and instructions. But what this is saying is, if on day 29 or day 59 or day 89, they claim that there was a form that you were supposed to provide, this says they should have gave it to you up front. Unless otherwise provided by the policy of insurance or by law, within 7 days after the insurer received proofs of loss statements, the insurer shall begin such investigation as reasonably necessary unless the failure to begin such investigation is caused by factors beyond the insurance control. Once again, there goes that factors beyond their control. What does that mean? If such investigation involves physical inspection of the property, the licensed adjuster assigned by the insurer must provide the policyholder with printed or electronic document containing his or her name and state adjuster's license number. An insurer must conduct such physical inspection within 30 days after its receipt of proof of loss statements. Once again, what they're saying is, if you didn't do that simple thing in the very beginning, when it came to following the duties after a loss, proof of loss statements, you're giving them permission to take longer, because they don't have to do this within 30 days if there was no proof of loss statement received. Any subsequent communication with the policyholder regarding the claim must also include the name and license number of the adjuster. So if you're in the state of Florida and you're getting communications by the adjuster and it doesn't include their name and license number, they have violated.